This is the Tom Bigby Tales, and I'm your host, Shannon Evans. I write about a small town in northeast Mississippi on the Tom Bigby River called Columbus, and sometimes I write about the rest of the state. This episode is Heritage Academy episode 15, where some children have no civil rights. Do children have a reasonable expectation of privacy in school? Legally, yes and no. They have a reasonable expectation of privacy and to be free from intrusion into personal matters, even in a school setting. There are two key federal laws that impact this: the Family Education Rights and Privacy Act, called FERPA, and the Children's Online Privacy Protection Act, COPA, that guide most educational institutions' use and protection of students and student information. But do children have a right to privacy? Yes, but those rights are not always clearly defined as they are in those laws that I defined up above, and as a result, school administrators and teachers often violate students' rights. Heritage Academy is not any different than any other school in that aspect. However, they might even be worse than most schools. For example, when the school wanted to find out if students were texting other students inappropriate photos based on something they were told, the school began to call students to the counselor's office. They searched multiple students' phones and then called the parents of those where they found questionable photos in their text or photo collections. It was a broad search of multiple students' phones, and while it did uncover that a student had sent compromising photos of themselves to an interested party, it was unnecessarily broad in scope and impacted children not related to the incident, but based on rumor and innuendo. The students were told, per parents with whom I have spoken, that the students had to surrender their phones for examination or be immediately suspended. Several children allegedly asked to speak to their parents first and were told by head of school Sean Harrison that the school did not need parent permission to search their phones. In other words, the school was victimizing children who may or may not have been victimized or were the victim of the actual situation. In several other instances, the school failed to protect students who were the victims of bullying and sexual harassment. It is alleged that the school counselor was notified by a family that their child had photos taken of them in the bathroom and circulated on social media. The counselor is said to have stated, quote, "Boys will be boys," and did not take the event as seriously as the parents thought the multiple humiliating events should have been taken for their child. The parents removed their student from the school, allegedly engaged an attorney, and to get their tuition returned and not face additional fees for not completing the school year, per their contract, they allegedly had to sign an NDA that they wouldn't disclose what had happened. And this is not a solitary case. Sexual harassment from male students at the school and from some staff has been ignored, swept under the carpet, or dealt with by quietly moving the victim to another class or even another school. The victim is often made to feel like they are not heard or even blamed for their own victimization. Remember, this is the same school where male coaches are allowed in the girls' locker room to coach and do pre-game warm-ups. Now, is it a crime for someone to take or record intimate video or images without knowledge or consent of the person being filmed? Taking nude or semi-nude videos or photographs without consent is usually a criminal act if the images are taken in a place where one can reasonably expect to have privacy, like a locker room or a bathroom. The right of privacy is invaded when there is unreasonable intrusion upon the seclusion of another. This is often referred to as the intrusion of solitude. Intruding upon another's solitude or private affairs is subject to liability if the intrusion is considered highly offensive to a reasonable person. This wrongful act is often associated with peeping toms, someone illegally intercepting private phone calls and messages, or snooping through someone's private records. Taking photographs of someone in public is not an invasion of privacy. However, using a long-range camera to take photos of someone inside their home or inside a place where they thought was reasonably private, like a bathroom, would qualify. The victim may take legal action for this intrusion. But my point is, the school should have taken legal action to make sure that the solitude and the preservation of privacy of the person who had their privacy breached on school property was protected. At the very least, the victim's lawsuit would be a civil one that they could claim that they, as the injured person, have suffered emotional distress and mental anguish. The school should take these actions very seriously. For example, let's say a woman was about to deliver a baby via C-section and she agrees to allow the operation to be filmed for educational purposes. Okay, if it's used only for educational purposes, that's her permission. But instead, it's shown to the public in a commercial theater. It then goes from being a matter open to the public to an invasion of her privacy. So, what if someone publishes an unflattering article about a politician known for their family values? So then the publication discloses that the politician is having an affair with a staffer. Here, the disclosure is a public concern and therefore not an invasion of privacy. For example, a teacher is having an affair on campus of a school that states that it is of high moral values and academic excellence. A publication or a podcast discloses that two members who are employed by that school are having an affair and both are married to other people and the affair is done on campus. Then that is not an invasion of privacy. But let's get back to students. Do students have the right to refuse to have themselves or their personal electronic devices searched? Well, yes, they always have a right to refuse a search, and they should make clear that a search is taking place over their objection if they do hand the phone over. They should get it on record that they want their parent or guardian present and that the school has refused to allow that. Can the school search your student without consent? Well, yeah, but only under certain circumstances. First, the school must have a reasonable suspicion that searching the specific student will turn up evidence that violated a school rule or a physical law, a law that's on the books in their community. Second, the way the school does its search should be reasonable and based on what is being searched for and the student's age. So, what is reasonable suspicion? Legally, there does not appear to be an exact definition of that, but a reasonable suspicion should be based on facts specific to the situation. It cannot be based on a rumor, a hunch, or a curiosity, which is very interesting because Heritage often starts their searches based on a rumor, a hunch, or a curiosity. For example, a teacher cannot ask to search a bag that looks weird and bulgy for drugs based only on the shape or appearance or even the symbols on the bag. Can the student conduct a random search of students in a school? Yes, but those random searches must be based on special school-wide needs, such as ensuring school safety, and should be truly random. A random search cannot be used to target any individual student. School administrators need to be careful about potentially infringing on a student's Fourth Amendment rights when searching a student's cell phone. Recently, there was a suspected case of a group of girls bullying each other at Heritage Academy and just being unkind and nasty. Allegedly, the women's athletic director, Mo Black, head of school, Sean Harrison, and the school counselor, Amanda Shilton, brought each girl in and took her phone and searched it. It's not clear what the outcome was. However, the search included texts, social media, etc., regardless of if the messages or texts were done before, during, or after school. The search seems overly broad and invasive. The school has a policy that all phones are to be powered off and stored in hanging shoe racks in the classroom. Students are allowed to have them during lunch or free time. However, they are not allowed to use them during assemblies, etc. If the search was necessary to protect a child from imminent threat, a specific time range and date range of a search seems appropriate. However, it has been alleged by the parents that the search was much broader in scope. The girls were told if they did not surrender their electronic devices to the school right then and there for examination, they would be suspended. These are all good students and highly motivated academically and athletically. A suspension would be devastating to them academically and athletically. So the threat worked. The adults essentially bullied the students into compliance and told the students they had no rights. And so their institutional hypocrisy continues. They can bully the children to get information about other children who they are bullying or are being bullied by. And then we wonder where children learn these bullying behaviors. Students do have a diminished right to be free from searches by school officials. The Supreme Court has said that a search of a school student is constitutionally permissible when there are reasonable grounds for believing the search will uncover evidence that the student has broken the law or violated school rules. The search cannot be unlimited, however, and must be reasonably related to the object of the search and not excessively intrusive. I have been contacted by several other families claiming their sons have been physically intimidated into allowing the school to conduct overly broad searches of their sons' phones and iPad by the head of school, Sean Harrison, and his former dean of students, Yandel Harris. Both men are large in stature, standing well over 6 feet and easily weighing 200 pounds. The students, right or wrong, were so afraid for their safety, they asked and then begged to have a parent present before corporal punishment was alleged to be delivered. More than one student called their parents before going into the office, already deeply afraid of the two men they were going to be sent to talk to, innocent or not. They physically feared two grown men in positions of authority. Parents allegedly arrived and were met with a rebuff and that it was, quote, an internal issue. Several fathers of high school students have told me that they have informed the school that any meetings with their student for disciplinary reasons will only be conducted with one of the child's parents present. Wow, good on those parents for supporting their students. While schools need good order and discipline, a child's fear of physical abuse by those in authority is never a good look in the modern world of education. Certain circumstances may justify at least a limited search of the contents of a student's cell phone in the school setting. Given the quantity and quality of data found on today's cell phones, however, administrators should proceed with caution when searching a phone without consent. An excessively intrusive search could violate the student's right of privacy under the Fourth Amendment and expose the school to liability. This could be costly to the school's reputation and to their coffers, especially with the number of children of lawyers and judges in Heritage Academy's enrollment. I find it interesting, though, how angry people are in the community about this podcast raising these questions and others about the behaviors of the school's leadership and its board of trustees. I also find it interesting that those most angry with the questions raised and concerns of parents this podcast has made public have been met with attacks of personal nature. Not one person who has attacked this podcast or this podcaster online or in a public setting has attacked the accuracy of the content. They can't, and they know they can't because the issues and concerns raised are real and the facts presented are usually substantiated with public record. This has created a conundrum for the warped herd morality of those who are most unhappy with a light shined on their elitist notions of heritage is the best, when clearly the current administration has serious issues that are being swept under the carpet and or trivialized by the Board of Trustees and the head of schools, Sean Harrison. Why? Cognitive dissonance? Stockholm syndrome? Clearly the mediocre among them have no capacity for self-reflection. No one has ever questioned this school and how they do things, not in 3 generations. The school is pissed off that anyone dares to question them. No one knows what to do or how to react, so they go right back to their normal behaviors and hope it all just goes away. They have no clue how to react to someone questioning their behaviors because it triggers their defense mechanisms. These questions that I ask are perceived as personal attacks and a challenge to their sense of authority and make them uncomfortable with the potential need to confront their own shortcomings and biases, especially if they are not used to receiving critical feedback. Instead of shooting the messenger, leadership at the school needs to create an environment that embraces institutional accountability, transparency, and a change embracing environment. Heritage cannot and will not change unless there is a large scale change in its administration, leadership, and board of trustees. Get the adult bullies out of the building and foster a true learning environment. Isn't that what you are paying all those bucks for? Until next time, this is the Tom Bigby Tales.